Ready.
Hey, this is Ed Sullivan and Marco Berti. Mark, as you know, in the last days of the George Bush administration, Congress passed and the President signed a new Americans with Disabilities Act, or ones that amended the prior ADA. The EEOC has now issued some guidance on that, and why don't you talk about what's going on with new ADA developments?
Sure, the EEOC is really on the warpath underneath the new Americans with Disabilities Act. They really want to go to court and get some good cases and prove the point that there's been a dramatic shift in employees' favor under this amended Americans with Disabilities Act. So the three areas that we see in 2012, and it's kind of a trend from last year that the EEOC is focusing on, one is rigid maximum leave of absence policies. So for example, Verizon had one that was very difficult and said, if you miss work for any reason, it's going to be held against you, and if you accumulate enough occurrences or points, you're going to be fired. And it didn't really take into account disability issues. The EEOC went after Verizon, $20 million settlement. And so rigid leave of absence policies is something the EEOC has a target on. The second thing they're focusing on is employers that screen employees out based on the perceived direct threat that they pose. So you see cases, and there's one from the Fifth Circuit where the EEOC sued in one where a lady worked for DuPont in a chemical facility, and they said, well, because of your back problem and you can't walk as fast, you won't be able to get out if there's an explosion, so you're a direct threat to your own health, and we've got to let you go. The EEOC said, no, that doesn't fly. You didn't rely on the most relevant, most critical, and up-to-date medical guidance. Rather, you relied on myth, fear, or stereotype. We're suing you, DuPont. They won $300,000, and the Fifth Circuit upheld it. So whenever you exclude an employee based on a proposed or perceived direct threat, the EEOC is going to scrutinize it carefully. And then finally, the all-important interactive process. The EEOC went after Chevron Phillips on that. They won that case in front of the Fifth Circuit as well, which of course has to do with the discussion the employer has to have with employees after they ask for an accommodation of some sort, and they really have to follow it through. You can learn more on the website, www.osattorneys.com.